so much for joining tonight. We'll be getting started momentarily. Thank you so much for joining us tonight. We'll be getting started in just a moment. Good evening or good afternoon, everyone, from wherever you are. Thanks so much for joining us tonight for Ask Me, our educational webinar series. My name's Audra Hines, Vice President of Care Services for the ALS Network. I want to thank our lead accessibility and inclusivity sponsor, Mitsubishi Tanabe Pharma America, and our mission benefactor families and everyone who helps support our programming. The contributions from these individuals and families are absolutely amazing, and programs like this one tonight, as well as the multitude of services we provide, would not be possible without these generous donations. Many of you joining tonight may know that we're now the ALS Network. While we had a recent name change from ALS Golden West to ALS Network, our organization and the services we provide are as strong as ever. Please know that if you need a piece of equipment loaned to you, emotional support or counseling, assistance with finding home care, help understanding your benefits, guidance in finding an ALS specialist or a clinical trial, or just someone with expertise to answer any other questions about the disease, the ALS Network is here for you. Our committed staff, who are locally based in California and Hawaii, provide high quality, personalized local services as we also fight on the legislative advocacy front and build our growing research program. We're your local team and are glad to provide multi-layered support. To learn more about the ALS Network and the menu of services we provide, please visit alsnetwork.org for more information. ALS is an incredibly expensive disease with costs for some families soaring near $200,000 annually. We know that you have questions about managing finances and planning for the future, which is the reason for our focused topic tonight. Our speaker is Kate Phelan, Senior Vice President and California Regional Director of Wealth Planning with U.S. Bank. She specializes in wealth and estate planning, addressing wealth transfer needs and researching fiduciary strategies. With a career spanning banking, financial services, and estate planning law since 2015, her expertise focuses on estate plans, philanthropic strategies, and advising on education and retirement funding, as well as California and federal taxation. Kate, thank you so much for being here. We're so pleased to have you with us tonight.
Thanks for having me. It's my pleasure to be here. Okay, is the floor mine? Can I share my screen?
The floor is yours, yes.
Awesome, thank you. I shared with the team ahead of time that I'm not the most tech savvy speaker they ever heard, but hopefully I'll make up for it with information today. So I just want to confirm, Audrey, you can see the slides.
That looks great.
Excellent. Okay, thank you. Good evening, everybody. As Audra mentioned, I'm here today to talk about estate planning. It's kind of a broad topic if you think about it. I think when we think of estate planning, we typically think of the transfer of assets upon one's death. So a will or a trust, and that is certainly a part of estate planning. But it also encompasses things like financial power of attorney, healthcare power of attorney, and we may even talk tonight a little bit just about basic planning, budgeting and thinking about, gifting strategies and things like that. So hopefully we'll get some questions, and I'm going to try to cover some broad bases. And certainly if anybody wants to reach out to me afterwards, please don't hesitate to do so. So I'm going to just kind of talk through estate planning, what are kind of the basics of it. So you can see here on the screen, these are sort of considered to be the suite of documents that are fundamental or foundational to estate planning. That one in the top middle, revocable trust, that sometimes depends on what state you're in, how important that vehicle may be. The things that a revocable trust does versus a will is it avoids probate because it is a contract, so there's nothing to probate. It's private, so nobody can look up and see how you're dispersing your assets. And it's a little bit more straightforward in terms of who's going to be in charge. So for those reasons, depending on how onerous the probate system in a state, for example, I'm sitting in California right now, our probate system is incredibly onerous. Places like Colorado or Washington, it's not quite as onerous, and you don't see as much of a need for that revocable trust. And we'll get into today how the revocable trust and a will are really similar. So those two vehicles, the will and the revocable trust, those are the vehicles by which we're going to distribute assets. And like I said, we'll get into that in a minute. And then there's a third way where you can distribute assets that don't include a will or a revocable trust. And this is one I don't think we spend enough time on because this can make things really simple in certain circumstances. And that's the designation of beneficiaries. So you think traditionally of beneficiaries being designated on an IRA, for example, a retirement account, or an insurance policy. Those are the places when you think, oh yeah, I have to set a beneficiary for those accounts. But you can use a beneficiary designation on a traditional investment account or a bank account. And when you do that, it's called a transfer on death or a designation on death or payable on death. And so you would see an account, for example, my account would be titled Kate Phelan, POD, beneficiary of my choosing. And so upon my death, that beneficiary would simply have to show up at the bank with a copy of the death certificate and say, I'm the entitled owner of this property now. And that's really simple. So you don't have to go through probate. You don't have to set up a revocable trust. And it's something that I think gets overlooked. You can even use a beneficiary designation for real estate in certain transfers. So I really encourage people to think about, is that a tool that might be beneficial in your own estate plan? Like I said, it gets a little bit overlooked sometimes. Then we'll see on the bottom line here, financial power of attorney, healthcare power of attorney, and living will. Those are all things that pertain to you while you're alive. So if you find yourself in a situation where you can't make your own financial decisions or you can't make your own healthcare decisions, who is the person that you would like to step into your shoes and make those decisions on your behalf, take on that responsibility? And then a living will, which can also be a document that we see called a multitude of different things. That's the document by which you're going to say, what are your wishes for your healthcare in this event that you become terminally ill? So now you're at a point where there is no more care that really maybe can be given. What do you want to have happen? And that's a deeply personal decision. And far be it for a lawyer or a doctor to make that decision for you. So it's really important to have those wishes on paper and have people empowered to execute against those wishes for you. So these are the suite of foundational estate planning documents that we're going to talk about today. Again, I'm going to be probably relatively high level on all of them. I'm happy to field some questions, but hopefully we can, like I said, cover some bases. So we'll go here, the last will and testament or a revocable trust. Now, if you have a revocable trust, you're also going to have a will, which is a little bit counterintuitive, perhaps. In the event that you have a revocable trust, it really serves as a bucket. While you're alive, that revocable trust isn't doing any tax planning yet. It's simply serving as a bucket, holding ownership to assets. And then upon the person who set up the revocable trust, called the grantor or the trustor or the settlor, upon his or her death, then that contract says, where do these assets go? But in the meantime, it's just a bucket that holds the assets. Simultaneously, you would have what's called a pour over will. It simply pours any assets into the trust that weren't properly titled into the trust at the time. Sometimes, if an individual or a married couple doesn't have a revocable trust, they simply have a will, and that will is going to be the document that says, where do I want my assets to be? So you can see here, these are the documents by which we're passing ownership of assets. A will in particular is where you're going to provide instructions regarding burial or cremation, or other arrangements that perhaps you've already had made or that you want somebody to make for you, right? Directions on what you would like your executor to do. The will also may appoint a guardian for minor children. So that's a really critically important use of that document. If there are minor children involved, really want to make sure that those appointments have been made, that those appointed guardians are aware of the responsibility, and that they've been designated as such. And then you can see here at the bottom, these documents require testamentary capacity in order to be executed. So I think sometimes when you think about a Lifetime movie or a made for television TV movie, you hear about, deathbed planning and was he or she really able to make the documents? And that's a dramatic spin on something that is important to consider. You really want to make sure that you're executing these documents while you are lucid, while you are in a place where you can make these important decisions about your family and about your assets, as both of them require proper capacity. Important to note that your financial power of attorney can't do this for you. It's something that you really need to do for yourself. I've noted here on the right of this slide, with regard to a trust does typically do a little bit more tax planning than a will does. That's not to say that you can't do that post-death tax planning via a will. But for those of you who think, maybe I've got an estate tax problem or some other tax planning that needs to be considered, the trust is probably going to be the more appropriate vehicle in that regard. So again, those are the documents where we're transferring ownership of assets upon death. I also want to note here, I think it goes without saying, but sometimes it's important to say it anyway. Those beneficiaries are whomever you want them to be in whatever form or percentage that you want it to be. And one of the things that you think about when you think about passing assets is not just who is going to benefit, but how are they going to benefit? So for example, if you're thinking about leaving assets to a minor child or to a child or a friend or a sibling or who has perhaps a gambling problem or a drug problem or other situations where you think perhaps you don't want this person to have full control of the money for whatever reason, then you may say, I want to give this money to somebody, but I want it to be held in trust for their benefit so that they're not, in control of the money. Particularly with minor children, when they can't be in control, it's important to say, okay, who's going to manage that money on their behalf? So it's not enough just to say, who do you want to receive the money? It's important also to think about how and when should they receive it. And also maybe what are the things that are important to you that you want to see the money used for. Again, I think a lot about minor children. If you want to, leave instruction in terms of paying for education or a wedding or a new car, things that you might do, if I were still alive, these are the things I would want to spend the money on. And you're giving that instruction to the person who's going to be in charge, and passing some of your financial values that way, which I think is a really important thing to think about. It's not just about passing ownership, which is a little bit clinical. Sometimes it's about your legacy and your values, and protecting the people that you love, sometimes from themselves, from creditors, from things like that. So an important thing to think about here in terms of passing ownership of assets. Okay, I'm going to skip over these next two slides because I think they're just, they go a little bit deeper into some of these, into those two vehicles. And I want to spend a little bit more time here. So powers of attorney. So there are, as I mentioned, two separate types of powers of attorney that you want to think about. The first you can see here on this slide is for financial and legal matters. So this is an important one because if you become incapacitated and you can't do, your banking business or transactions, if, you see here, real estate needs to be sold perhaps, or you need to make some decisions with regard to an investment account, or you need to simply have checks written on your behalf to vendors or caregivers or the like, somebody needs to have the authority over your finances in order to do that. And so in that case, you as the person who is appointing this power are the principal, and you're giving that authority to an agent. So the agent is the one who is going to present to financial institutions or real estate agents or the like, saying, I'm here representing this individual who cannot represent themselves. There are two types of financial powers of attorney, and I think this is really important to think about depending on your own circumstances and depending on the person that you're asking to serve. The durable power of attorney, it's effective the moment that you sign it. And it is really not impacted by whether or not you are actually incapacitated. So you may just be on vacation and therefore unable to sign a document, or you may just say, you know what, I just don't want to deal with it. So it's not dependent on whether or not the individual who's making the power of attorney has that capacity. It is effective the moment it is signed. On the other hand, the springing power of attorney, this one only takes effect at the point that the principal becomes incapacitated. So you've been deemed incapacitated by whatever metric your estate plan provides to say, this individual no longer can make his or her own decisions, can no longer appropriately tend to his or her affairs. And at that point, then the agent may step in. And so they're also probably going to need to demonstrate, there's been a determination of incapacity, and as a result, now I'm serving. So again, depending on who you're appointing, depending on the nature of help that you need from them today or immediately, one of these is going to be appropriate. And again, as with most things in estate planning, it's a very personal conversation or a very personal decision. And I think benefits from having a conversation. When you're asking somebody to be that agent, it's important that they really understand what's the responsibility here, what's the red tape I'm going to have to deal with the banks and other institutions. How do I make sure that I have my ducks in a row? What is the timing of when you're asking me to serve? Making sure that they have a copy of the documents, things like that from an administrative perspective are really important to make sure that they're empowered to do a good job for you and not hindered in that responsibility. So that's the financial power of attorney, or durable or general power of attorney, sometimes it's called. Okay, the advanced healthcare directive, and I'm actually just going to sneak a peek. Okay, I thought maybe I'd missed a slide. Apologies. The advanced healthcare directive. So this is the umbrella of healthcare decisions, and we talked about this a little bit at the outset. So there are a couple of different important decisions that you'll need to make when implementing these documents. First and foremost, how do you want to be cared for? What's the extent of care that you want under certain circumstances? Making sure that you have those decisions memorialized. Doctors want to know that you've made those decisions somewhat recently. So if you have a living will that is perhaps 5 or more years old, I really encourage folks to implement or execute an updated one. Doctors, just in an environment today that is so full of litigation, they're understandably a little bit afraid to take action against a document that they deem to be too old or that they think that the patient hasn't thought about recently enough. So these are documents that I would recommend updating every couple of years as just kind of standard practice. So again, we're thinking here about making those care decisions, making sure that those care decisions are in writing, that they're very clear under what circumstances do you want all efforts to be made to keep you alive. Under what circumstances would you prefer that no efforts are made to keep you alive? Again, deeply personal, not in my opinion for a lawyer or a doctor to decide for you, but important for you to have, written out very clearly. Also, really important that you designate an individual for this that you feel is going to be a good advocate for you in the healthcare delivery system. I don't have to tell any of you on the call that the healthcare delivery system is very difficult to navigate. My husband was recently diagnosed with cancer, and so I can tell you firsthand, it's difficult, right? You just sometimes what the doctor say and the insurance company says and the nurse and everyone, it doesn't line up. And again, I don't have to tell you on the phone about that, but you want to make sure that the individual that you're going to empower to advocate for you and to make decisions for you is somebody who can navigate that system, who can really be a strong advocate for you and can implement what your wishes are. So it's not always your favorite child or your best friend who's going to make the best healthcare agent. So, really think carefully about who that individual or individuals may be. In the event that you appoint more than one individual, and I see that most frequently with children, right? When an individual wants to appoint more than one of his or her adult children, and that certainly makes sense, right? You don't want anyone to feel left out. There are administrative hiccups to that, and you really want to think carefully about, does everybody need to agree? Does everybody need to have signed off on it? Is there one person who's the ultimate decision maker, so that you don't get into a situation where the signatures and the agreeing is what's going to slow down the process of making an important healthcare decision. I would say the same thing about a financial power of attorney. I didn't on the last slide, but I would say it's the very same consideration there. Anytime you have more than one person who is going to be stepping into your shoes or acting on your behalf, you want to be really careful to make sure that there are some guide rails and some rules of engagement on how that's going to go. And then you see here in the gray box, HIPAA, again, something that I'm sure is very familiar to everyone on this call. You want to be really careful about who is receiving your medical information. So, this is where you say, you know what, I'm allowing my agent to have the information about my medical well-being that's going to help them make the decision. So that'll be a really important part of it, that authorization or that release has been made so that your agent can get the information that he or she needs, again, to act on your behalf. Really important, in my opinion, that the agent have a copy of this document so that if you find yourself in the hospital or in a situation where they need to step in right away, there's no time lost looking for the document. Does the doctor have it? Is it in the file? So on. I think it really makes a lot of sense to make sure that healthcare agent already has a copy of it and that they know they've been appointed to serve in that capacity and they're ready to go in the event that they need to. Okay, beneficiary designations. I should have put this slide in front of the POAs. I apologize. I must have had a bit of a brain fart. We talked about this. I will just dwell on it again because I think it's really important and I'm seeing more and more use of the beneficiary designation. And I think the biggest reason for that is that you don't have to go to a lawyer and have a document drafted. The will and the trust are really going to require that you visit a lawyer and spend money on documents, or at the very least try to do it yourself with a legal Zoom or something like that. The beneficiary designations are much more straightforward. And again, you can use them on a really wide variety of assets. And it's really simple then at the time of death that the beneficiary simply presents and says, I'm going to be the rightful owner of this account or this policy, et cetera. So it's something that I really encourage people to think about on a variety of different accounts in different situations. So out of order, but worth dwelling on again, because like I said, I think it's an option that gets really overlooked. It's deceivingly simple in a really good way. And I'm a big fan of simplicity, right? When you're in a situation where you're making these types of decisions and you don't have a lot of time or your focus is elsewhere as it should be, the simpler, the better, in my opinion. So I do like to make sure that people think of this as kind of that third asset transfer option that can be really beneficial. No pun intended, beneficial beneficiary. Okay, let's spend a couple of minutes on advanced estate planning. So this is a realm of estate planning that pertains to folks who have a taxable estate. You can see here, and I just realized that this is the 2023 slide. I apologize. A taxable estate means that an individual or a married couple have an estate that upon their death is going to be subject to federal estate tax. That number is north of $13 million this year. So as a married couple, north of $27 million that just by showing up and being a taxpayer, you can shelter. There's a lot of discussion in the media right now about that exemption sunsetting. So that number that you can shelter from estate tax is called the exemption. It's set to be cut in half at the end of 2025. And depending on what happens in Washington in November, that may or may not happen. So folks who have a taxable estate, so really a substantial size asset base, the basic estate planning that we just covered, critical for everybody, regardless of what one's balance sheet looks like. These are things you've got to be thinking about. Everything we've talked about, applicable for everybody. For those who have a taxable estate or a tax problem, there are advanced planning documents that may be at least worth considering. I think it's really important to think about the fact that, and you can see kind of a litany of acronyms over here to the right, these are mostly irrevocable trusts that are used for wealth transfer planning. So how are you going to transfer wealth intergenerationally, so usually to the next generation down, in the most tax efficient way? I always want to caution people that these are tax plays, right? So doing this is very tax efficient, and depending on the situation, certainly an important tool that some folks may exercise, but it is all about taxes. So it doesn't necessarily always answer the questions about your financial values or how your family is going to feel about having to deal with these gifts, etc. So while they are really important to think about for folks who are in that taxable estate realm, I sometimes see a lot of people for whom this planning would make a lot of sense say, it's just a little too complicated, or no, it's not for me. And again, like I said, as with kind of everything with estate planning, a personal decision that needs to be decided as a family. But I'd be remiss if I didn't note that there are kind of, again, a litany of different trusts that can be used, as well as charitable planning. Being charitable, luckily for society, is also really good for taxes. And so it's a great way to reduce your taxable base. It's a great way from an income tax planning and an estate tax planning perspective to be more efficient. And it's also good for society and for the community. So those are some of I've listed here some of the different types of trusts that we see in that advanced planning world. Not going to get into the nuances of those tonight, but just want to say that that's kind of the next chapter for folks who are facing an estate tax problem. Okay, I'm going to stop sharing and maybe stop talking for a minute. And I don't know, Audra, if we're able to open it up for questions on the fly. Would love that.
Yeah,
or if there's absolutely.
No, that's perfect. Thank you so much. Yeah, and if there are other slides you want to get back into, Kate, totally fine. If we have time for that, we do have a few questions. First, I don't know if this one is complex or not. So this person says, I'm needing to remodel my half bathroom and a couple of different doorways to give me better access based on his ALS disability. Our other full baths are upstairs. I won't be able to eventually manage to getting into those. The only place I can pull money from is my IRA. I'm 72 and still working, and wondering how taking the money from the IRA for this remodel is going to affect my taxes, and will I be able to write any of that off due to having a disability?
Great question. So at the age of 72, there will be no penalty for taking the money out of the IRA. If you take money out of your IRA before 59, they take a haircut on it. They penalize you for that. So at age 72, there's not going to be any penalty. It will be taxable, however. Distribution out of an IRA is taxable on your income taxes. With regard to can you take a deduction, that's at the risk of sounding like a recovering lawyer. It depends. There are some provisions around, improvements to your home, both from a disability perspective, but also just from improvements to your primary residence. So that would be something that I would recommend talking with a CPA about to see, is there some flexibility there or some benefits, but you can take that money out of your IRA without incurring any penalty. And depending on how far into 72 you are, you might be required to take the money out of the IRA anyway. So that would be, it may be a situation where you have to take it anyway.
Gotcha. Okay, that's awesome. And for anybody who has a question, just please feel free to put it into the Q&A function that's at the bottom of your screen. What happens when an asset is named in a will and there's also a beneficiary designation that might list a different individual?
Ooh, that's a great question. So typically what happens is the beneficiary designation is going to trump the will, because now you've by the four corners of the document. And so in this case, the signature card for a bank account or the agreement that you have with an investment firm to manage your money, the four corners of that document now tell us where the assets go. And so the financial institution is going to look at the documents and say, okay, these go to Uncle Joe, your Uncle Joe, here we go. So it's important, if you do the beneficiary designations, that you also look at, what does my will say? Even if you wrote your will and Carter was still president, it's important to know what it says and make sure that everything that you're doing now isn't going to create a discontent, right? Because you don't want your family to end up in court or mad at each other because the documents don't agree or they don't agree with what you want to do. The thing that we also look at in a situation like that, when two pieces of an estate plan don't match, which one was done more recently, right? There is credence given to the last thing that somebody thought about. So the more recent document usually will also prevail. But again, just really important to make sure that you're not creating something that is just a discrepancy for your family to clean up.
Gotcha. That's pretty helpful. Thanks. We get asked this question a lot. What's the difference between a POLST form and an advanced healthcare directive? Do you need both?
That's a good question. A POLST form.
Right. So a POLST is something that typically a physician would need to sign. POLST. Advanced healthcare directive, obviously not. You're creating that on your own.
Yeah. So I would not say I'm an expert on a POLST form, although I've already just made a note to myself so I can become an expert, and I may need to circle back. But let me make a couple of broad comments that may help to answer it. Doctors, as everyone on this call knows all too well, are terrified of their own shadow sometimes, and I can't blame them. They want to make sure that all of the ducks are in a row, that the patient that they're working on has made decisions, like I said, when they're lucid. So really, did this person have their marbles about them? And did they make this decision somewhat recently? Now, in addition to that, they may also have forms that their providers or their hospital network requires that they have. And so I think it's important to make sure, do you have the documents that your doctor who's caring for you requires, right? Because at the end of the day, it's that doctor who is going to execute against the decisions that you've made, more than likely, right? Now, there may be a situation where you end up in an emergency room or something like that. But for the most part, you think about your care team being the ones who are going to implement your decisions. So it's important that you have the forms that they feel comfortable with, regardless of what those forms look like. I'm a big believer in kind of a belt and suspender approach, particularly when it comes to these decisions and how deeply personal and deeply difficult they are, right? Depending on what decisions that you've made. I think that it's important to have, yes, the documents that your doctor wants, and in addition, have the healthcare power of attorney, have that living will, have the healthcare directive. Those forms are not exceedingly difficult to have prepared. There are forms that you can find online that actually work. And I'm not usually in the business of saying, oh, just go online to do estate planning. But I think it's just too critically important so that if a trip to a lawyer is a barrier that somebody just simply can't get over, there are, use the internet. The internet's an incredible resource. Use the forms that your doctor has available, but make sure that you have those decisions in writing. And that, again, you've got copies. The people who are going to need to make those decisions for you have copies, and have that conversation with your doctor, right? Because not everybody on this call's doctor or care team is the same or in the same position. So just make sure that you have those really in place the way that your team wants you to, and then update them a lot. Because I have seen situations where a doctor says, this patient executed this document too long ago, and I don't know that this is still what they wanted. And it was, that's horrific. That's the last thing that anybody wants. So I think it's really important to keep those updated.
Yeah.
And I'm going to circle back. I'm going to become a post form expert, and maybe
Yeah,
I'll circle back
no,
and share more
that's
wisdom.
good info. Right. The Post is more focused on medical orders, and the Advanced Healthcare Directive is coming more from the patient. So yeah, that's perfect. Another question. Someone says she's selling her house due to not being able to live alone anymore. She will not be reinvesting the income she gets from that sale, but saving it to pay for caregivers. She says she assumes this will count as income and it will be taxed, but she just wanted to ask that question.
So actually, no, is kind of the short answer. Let me expand on that a little bit. So the sale of your home potentially will be taxed, but it's not an income tax situation. It is a capital gains situation. So when you think about, and I'm just going to use round numbers here because I'm not that much of a mathematician. Let's say that you bought a house for $100,000 and you're going to sell it now for $500,000. That $400,000 that the value of the house has increased is going to be subject to capital gains tax. And capital gains usually is about 20%, depending on your income tax bracket. It may be a little bit less. With a primary residence, when you sell a primary residence, the first $250,000 of that gain, so in my example, it was $400,000. That first $250,000 is going to be tax-free because it's your primary home, and the Internal Revenue Code allows for you to have a little bit of leeway there, right? That's one of the benefits of owning a house, and so you can save that on the capital gains. Also, in my example, you spent $100,000 to buy the house, but you also want to look at, did you ever redo the kitchen or redo the floors or put, what are some of the improvements that you may have done on the house that then can increase the amount that you paid to own the house and therefore reduce the amount that is going to be taxable upon the sale? So that's a really good question. And that's one that is much more advantageous than just receiving money the way that you would from your job.
Gotcha. Makes sense. If you have no one in your life who's capable of handling your trust, what are your options?
Sure. So, good question. And I'm going to actually answer that question and a related question because there's a couple of different answers. When it comes to your trust or your will or the orderly disposition of your assets, the options are, as we discussed, right? A loved one, a friend, a sibling, a child, your neighbor, so on. It may be a bank trust company. So you think of your favorite local bank or standalone trust companies. They are professionals who are corporate fiduciaries who can say, okay, we're going to step in and deal with the estate settlement, make sure that all of the money is dispersed in the manner that it's supposed to. And then the third option is something that's called a private fiduciary. These are individuals who are licensed by the state. In California, it's called PFAC, the Private Fiduciary Association of California, similarly licensed in every state. These are individuals who can come in and do that work for a fee, similar to the way that a bank trust company would charge a fee, and implement your wishes. So generally speaking, a private fiduciary is going to be a little bit more flexible than a bank that is regulated by the federal government. So depending on what your circumstances are, if you don't have a loved one that you want to ask, there are pros and cons to using a corporate trust company versus a private fiduciary. Again, the size of your estate, the nature of your assets, the nature of who's receiving it would all be things that would be worthy of consideration on which avenue is the best for a professional. One thing that is really important to think about is if you don't have a loved one who can serve as your agent, either your financial agent or your healthcare agent, a bank is out, in my opinion, because the banks are almost all the time going to say no to serving as a financial agent, and they are every time going to say no to serving as a healthcare agent. So just as a threshold matter, those are areas that you don't want a bank trust company involved in. But a private fiduciary may get involved, and a private fiduciary may sometimes even be willing to be involved in the healthcare agent. Now, again, that's very sensitive. You want to meet with somebody ahead of time and say, is this something that you're willing to do? Make sure that you have that relationship organized ahead of time. But there are professionals, again, the bank trust companies and the private fiduciaries being the main. Now, if you find somebody who's holding themselves out as a fiduciary and they're not licensed, I would proceed with extreme caution, because I think that licensure by the state, while it doesn't mean that private fiduciary is going to be perfect or even good, it's a very good start, right? They have met a certain threshold to receive that licensure from the state.
Great information. Thank you so much. Yeah, we're getting some really good questions. What happens if you are a single adult who designates adult children as your beneficiaries, and then you later become married? Does the spouse automatically become the beneficiary, or does the designated beneficiary hold?
The designated beneficiary would hold. Now, there's one consideration, which is with regard to retirement accounts. When you inherit a retirement account, so an IRA, 401k, something like that, the benefits to giving it to your spouse are so great that there's kind of a presumption that you would give it to your spouse. And if you're not going to give it to your spouse, he or she needs to sign off saying, I understand that you're not giving your retirement account to me, but you're giving it to perhaps your kids from a first marriage. And so almost all, I think at this point, state statutes require that you have the spouse sign off, and the institution where your IRA is being managed is going to be on top of saying we need to get that signature. Now, if the beneficiary designation on your retirement account predates the marriage, in my opinion, that beneficiary designation would still hold and would trump the marriage, because the marriage didn't exist at the time. But I mentioned earlier, I'm kind of belt and suspenders. I think it's not worth it to assume that that's how the financial institution would proceed. And if you get married, I would just take the half a day it takes to get the form and refill out the form and say, I'm married now, but I'm intentionally not leaving this account to my spouse. He or she has signed off on it, and it needs to go to my adult children. Just because you got married doesn't mean that you have to give everything to that spouse. And oftentimes, in fact, that's not the presumption, right? The presumption is what you did before, the money that you had before you got married, it's yours. So not something that you need to be worried about, that the new spouse being able to come in and take that money away from the kids.
Okay, that's great. Great, very helpful. This is interesting. So this person says her husband died last year of ALS.
Oh, I'm so sorry.
Yeah, she's filing a 706 this fall. She got an extension. She
Okay.
has listed artworks in the notarized form under assignment of personal property.
Mm-hmm.
And she's asking if she can place an inventory with date of death valuations with her trust documents. Does she need a separate trust for valuable artworks, or can she just file a list along with deeds to the real estate?
Yeah, so great question. Very, very interesting question. So I would say, as a threshold matter, adding that valuation, the valuation that you had done with the 706, probably also includes a really detailed inventory, because they're pretty diligent about that with a 706. Including that with the trust is a great idea. Leaving that art in the trust is perfectly suitable and adequate. So there's no problem there. The only time I would suggest is there a need for a separate trust is if you were doing tax planning with the art collection, right? So if you said, I'm going to put it in a trust because I'm gifting it away and going to leave that out of my estate, in which case your lawyer would say, okay, we're going to put those assets in a separate trust for tax planning reasons. Or actually, you know what? I'm not going to complicate it. That would be the only reason you would need to do it separately. You can still, in the terms of the trust, say if certain art needs to go to certain individuals, you can use that inventory and reference that inventory. Or you can say, all of my art collection goes, perhaps to my children or my friends as they may designate. But yeah, that transfer, where you put the assets in the trust in the first place, that got the job done. And then having that inventory is a really good idea. That kind of inventory is a good idea always. When you're thinking about personal property, I think it's really important to be specific. So, for example, I'm wearing this ring today that my mom gave me. It's got a nice little sapphire in it and a couple of small diamonds. Use some specificity, right? So that if somebody reads the description, they can say, okay, don't just say ring from my mom, describe it so that someone can pick it up and say, this must be the ring and it needs to go to whomever. So for those of you who have that personal property where you want to be really specific about who's going to receive it, use that specificity. Pictures are great, descriptions are great. I can't tell you how many times I've seen someone say, my diamond ring. Okay. And then you've got somebody who maybe has more than one, or you're not sure. So again, using some of that specificity, I think, is really important. But yeah, the art collection is in your trust, and that's a great question.
Thank you. Different topic. Can an appointed healthcare agent override a directive I've made in my advanced healthcare directive?
No,
Yeah, that's pretty easy.
no, they can't.
There
And
you
if
go.
you think somebody's going to do that, I would recommend not appointing them. They
Yeah,
sound like a jerk.
yeah, fair enough. Fair enough. Um, well, this might be is a little different but related. Can a living trust be contested? We talked about a little bit earlier. Is it better to have an independent trustee versus a family member or friend?
Sure. So, both good questions. Yes, a living trust can be contested. So, if you are thinking about leaving a loved one who would otherwise be entitled. So, if you leave your friends out of the trust, unlikely that they're going to have a leg to stand on. But if you are intentionally disinheriting a child, or if you don't have children, you're intentionally disinheriting your parents or your siblings, whoever may be in line next, you want to be really express about that in the document. I am intentionally omitting provisions for this person or for this group of people. And they, as somebody who would legally, if you had not done the estate planning, have a right to your assets, also have a right to contest it. Now, most wills and trusts, you will see a no contest provision where it says, if you make a big stink about this, you're not getting anything, or you're getting $1. And that usually prevents people from making baseless claims against the trust. But it doesn't stop everybody. So you want to be really careful to make sure that you that you've put those provisions in to say, I've intentionally left this person out, which you're allowed to do. That's why you do a will and a trust, because if you don't, the state where you live in has a plan for you, right? In California, it goes to your kids. There's an orderly plan in every state about what happens if you die without a will or a trust. It's just probably not the plan that you want. It's kind of a misunderstanding that it goes immediately to the government. That's not true, but it doesn't always go to the people that you want to. There was a second part to that question about the contesting it.
Let me take a quick peek. Yeah, it was, yeah. Oh, is it better to have an independent trustee versus a family member?
Oh, right. Yep. A great question. So I think the answer again is it depends. So appointing a loved one to serve as your executor or your personal representative of your will or as the trustee of your trust is a lot of work. There is a reason that people do it as a profession, and there's a reason that it's a really major part of most wealth management shops at big banks, is that it's a lot of work. You have to do things in a very orderly fashion, in a very timely fashion. Certain people need to be given certain information. Certain people are not entitled to certain information. It's just a lot of work. And it's a lot of work that has to be done at a time of profound grief. So if you've just lost a loved one, now you're being asked to take on a full-time job that chances are you don't know how to do. And so although your loved ones would be entitled to compensation for that, they oftentimes don't feel like they should take it, or they don't feel like they know what they're doing. And then just to make things a little bit more complicated, money unfortunately has a tendency to bring out the worst in people, or to bring out difficult things. You see people get upset about things that happened at Christmas in 1987, and you realize how sometimes, really deeply difficult it can be. So if you have a family situation where you think that there may be some animosity among loved ones or among your heirs, or you think that you're going to ask one person to be in charge and then everyone else is going to kind of resent them, those would be reasons not to ask an individual that you know and love to do that work. The reason to ask them is sometimes you have somebody in your life who just already knows everything about your situation, knows exactly how things would be handled. It's simple, right? Maybe you've got only beneficial designations. It's pretty easy. Maybe it's all just going to my spouse. And so if you think it's going to be relatively straightforward, there are certainly lots of times when a loved one is absolutely appropriate. But if any of those other situations pertain, or it's you just think, this might be too much work to ask of my loved ones, that's when I really encourage people to think about a professional. There's a reason that they're out there. And oftentimes people will say, well, the fees are so high, I can't afford it, or it's not, my estate's maybe not big enough, what have you. And the reality is that if a loved one steps in, more likely than not, they're going to need an attorney, and they're going to need a CPA, and they're going to need someone to invest the assets, and they're going to need someone to do this, that, and the other. And a private fiduciary or a bank trust company is not going to need as many of those outside advisors, because they don't need to be told what to do. They don't need to be brought up to speed on how the probate process works. We don't need to hire an attorney to do that. We already know how. And so those would be the reasons that you would think about a professional, because your loved one is going to have to spend the money on those advisors anyway. So don't let the fees be the reason that you don't do it. Really think about, what is the complexity of my situation, and might I want to get a professional involved, even if it's just as a backup plan, right? Appoint your loved one, and then if they're unable or unwilling to serve, then it goes to a private fiduciary or it goes to a bank, and you've got that backstop for them, so they can say, this is too much for me.
Okay, that's perfect. I've got maybe just time for one or two more questions. Does your checking account that's in your trust, do you need to have the information, like account number and stuff, about the checking account listed somewhere in the trust? Does it need that kind of detail?
No, and oftentimes I encourage people not to include that level of detail in the trust. Maybe you just say checking account at Wells Fargo. Just because I'm a little bit nervous in today's day and age with fraud, of having that kind of information just out too many places. But what is important is that you've actually put the account in the name of your trust. So check your statement, check your checks, check anything you can to verify how the account is open. It should be in the name of your trust as opposed to in your individual name. So if you have a revocable trust and it's your intent for that to be the bucket that owns all your assets, it's important to make sure you've actually put the assets in the trust. Otherwise, you've built a great house and left all the furniture in the living room. So check your statements, check the deed to your house, make sure, is the designated owner my revocable living trust? No tax implications to that, no control implications, no property tax implications to that, but simply going from I as an individual to my revocable living trust owning all of your assets is a really important step. But if you're going to list the assets that are in the trust, no need to list the account number and all of that. In fact, in today's day and age, I'm nervous about that.
Agree. Okay, I'm going to squeeze in one last question. If I have charitable beneficiaries, what assets should I give to charity versus to my family?
Oh, that's a great question. A couple of different ways to answer that. So I think it depends on what percentage of your assets are going to charity versus your family. I think it depends on the size of the charity that you're going to benefit. So if you're thinking about benefiting a large national organization, they may be a little bit more well suited to take a gift of real estate or a gift of the art or something like that that's going to need to be dealt with. Whereas if you have maybe a smaller organization, they're probably going to prefer that they receive cash or liquid assets that they can readily sell the next day and that they can just put into their operating fund or, if you've designated it in a certain way. So a little bit, it depends on the charity. If you're giving assets away upon your death, everything is going to receive a step up in basis. So gifts that are made upon death, there's a lot more flexibility on what assets does your family want? What assets does the charity want? Because it's all had that step up in basis. If you're making gifts to charity while you're still alive, then we get into the nuance of, is it an asset that has a lot of appreciation and maybe you're trying to avoid that capital gains exposure that we talked about earlier, in which case you might want to give assets in kind. There's more nuance that goes into it for gifts that are being made while you're alive. But gifts upon death, it's much more a consideration of what are the assets that people really are going to want, right? And typically your family is going to feel more sentimental about the house and grandma's china and the art collection and things like that. Whereas, cash and securities might be more appropriate for the charity.
Kate, this has been wonderful. Oh my gosh, this hour flew by, and I know how much our audience appreciated this. We're going to do some closing slides, but if you're open to putting your contact info in the chat for people who might want to reach you, that would be awesome as we close. Thank you.
Absolutely. And I'm going to take myself off video and mute because I know you're going to take it away, but just thank you for the opportunity to be here. It was great.
Thank you, Kate. You were amazing as always. Thank you so much. And really, thank you to all of you for joining us tonight. We're really grateful to each of you for your time and commitment and just for being a part of our community. Once again, a big thanks to all of our sponsors for their support. And if you have other questions that weren't answered tonight, including questions about estate planning and planned giving, please email Mike Welling on our staff. He's our Senior Director of Planned Giving at the email address on your screen. The ALS Network brings the ALS community together in various ways throughout the year to create help and hope for families impacted by ALS today and for those who will be diagnosed in the future. These celebratory and meaningful gatherings provide opportunities for connection and raise awareness and funds to benefit ALS Network's mission priorities. Please visit events.alsnetwork.org to learn how you can join us. And as you know, philanthropy fuels everything we do, and we're grateful to generous donors who make gifts of all sizes throughout the year, including contributions through an estate plan. To learn more about how you can support valuable programs like this one tonight, please visit our website at give.alsnetwork.org and watch for the short survey on tonight's presentation that you'll receive via email to help us plan for future programs. Thanks so much again, and we'll see you next time.